Welcome everybody. This is the Legalities of CBD panel, where we will be discussing the legalities of CBD, the lack thereof, the gray area that CBD sort of occupies in both federal and state law.
My name is Alex Buscher. I'm the founder of Buscher Law, LLC. We are a firm specializing on the hemp industry. We do everything from cultivation, licensing, all the way to export. Really full service firm. We can do everything from securities, just to general formation. Recently sat on the CHAMPS committee, cultivation committee, which is responsible for helping draft the state plan that Colorado will be submitting to USDA. And I also sat on the Marijuana Enforcement Division Sunset Bill Committee, where we were helping to merge the codes, both the medical and retail codes, for 2020.
So Alex, the FDA has largely made public statements about ingestible products such as gummies, tinctures, things of that nature. So I know that a number of my clients are starting to produce hemp-derived extract cartridges and even usable hemp joints, pre-rolls, things like that. Would you say that the FDA has the authority to regulate those items as well?
So I think there's a clear answer to this with two caveats. As always, being a lawyer. So first, I don't think that currently, with the FDA positions they've taken, that they have the authority to regulate hemp vape cartridges and hemp cigarettes, as long as there's no tobacco products in them. FDA has clear authority to regulate nicotine because they have interpreted tobacco to mean any tobacco derivative, which includes nicotine. So if you're mixing your hemp with nicotine, you are likely going to be, or the FDA has authority over you because of their authority over tobacco. If you just have hemp cigarettes and hemp vape cartridges, it's much more unlikely that the FDA has authority unless you make a medical claim, because as soon as you make a medical claim, you've now made yourself a drug, your product a drug, and now you've put it's a misbranded and adulterated drug, potentially in interstate commerce. So that's the one caveat would be the medical claim, and the other one is FDA could always find a section of law, I haven't found one yet, where they could really just say, oh, we can interpret this as we can regulate any smokable product, but under Chevron deference, agencies have a lot of latitude in their interpretations. So just because they're not saying they can regulate it explicitly today, doesn't mean that tomorrow they don't find some section and reinterpret and say, oh, well, now we have authority over hemp too and all smokable products. I don't see that happening yet. I haven't seen haven't heard anything about FDA moving that direction. But agencies have a lot of authority, and as we've seen with DEA and other agencies, a lot of times they'll act first and deal with the repercussions later. FDA hasn't been as aggressive about that, but it's always a risk. So the answer is currently, I do not believe they have the authority to regulate, but that's not saying that they couldn't find a way to believe they have that authority.
So I just want to open this up to the entire panel, but can we talk a little bit more about medical claims, what that means? Does that only apply to labeling? Does it only apply to official marketing materials, or does it also apply to things like social media and consumer testimonials and things like that? What is a medical claim?
So the FDA has made very clear that anything that you put on your website, including testimonials or even links to other websites with medical information, will be taken by them as an adoption of your company of that statement and then imputed onto your label. So anything you put out on your website, social media, anything with testimonials, anything with even links to other websites have been found by FDA to be medical claims, and then companies have actually received letters just because of those testimonials or links to other websites.
Hi, thanks. My question is about testimonials and comments. We've had customers make YouTube videos and stuff like that we have absolutely no control over. So if they're testimonials or whatever that aren't on your website, are we concerned about those?
I'll jump in on this. So I would say that if you've linked in any way or promoted that testimonial in any way, and there's a paper trail or a link trail back to your website, you would have some liability. But if you have a customer who's just expressing their experience with your product and you haven't promoted or adopted that statement in any way, I don't believe that would implicate your company.
I agree with that, and the answer is you're not the police for the world, so you don't have the obligation to go onto social media to monitor it. You have the obligation, once it becomes known to you as being suggested, to take action and certainly not endorse it.
Is that the FDA does not require pre-approval before you put a topical or cosmetic onto the market like it would with a drug or a dietary supplement. But there are still regulations that require that topicals and cosmetics are not adulterated or are not harmful to your health. So, but generally, I think it's a lot safer way to go than, say, an ingestible.
And that's why you're seeing the topicals pop up at Walgreens and Whole Foods and CVS, is because the FDA has pretty clearly stated that right now they're not going after topicals. And you'll actually see CBD labeling on topicals and CBD isolate put into topicals because of that, whereas isolate and CBD labeling in tinctures are much more risky, and CBD labeling should not appear on tinctures in general.
And just to kind of piggyback on what was said here, what you have to be careful about with cosmetics is, are they being marketed truly as a cosmetic or as a delivery device for something else that could be considered a drug? So if you just have a moisturizing cream, and all it's going to do is kind of make you feel good and look good, that's a cosmetic. If it's a medicated cream, if it's something that is being peddled to treat a skin rash, for example, now you're talking about a drug. Okay, even though it's a cosmetic, it kind of morphs into that other category. So you have to be very careful about what the product is and how you're pitching it. And if it's just a moisturizing cream, that's a cosmetic. If it's just a cleansing, this is another thing. If all it does is clean, that's fine. Then you don't need, as Alex was saying, pre-approval. Okay, because there's a lot of things the FDA says you can only do it if we approve it first. Cosmetics is not one of those. Cosmetics, you can just market those, you can make them and market them as long as you follow the labeling requirements and as long as it doesn't morph into a different kind of product, like a drug.
And there's even more nuance with this. A lot of topical companies are trying to put out sunscreens. Sunscreen is inherently a drug, so now it gets very, very complicated. So putting CBD into any sort of cosmetic that's going to be used as a sunscreen or has any sunscreen ingredients, that makes it a drug product. So that's another area to stay away from.
Well, but it's important to know your state laws.
And I would add to that it's important to know the state law regarding hemp as well, not just Food and Drug Law, because there's still some states where if you would send any product containing CBD, it's marijuana, and it could actually be considered hashish because it's an extract from marijuana. So you could be sending a CBD tincture into Idaho or South Dakota, and they could charge you with trafficking hashish. So just really know your state laws. So I had an opportunity to work on the safe banking ancillarily, and initially the bill only related to marijuana because they defined cannabis-related business as marijuana business. There was a major issue with that because we knew that if it got to the Senate, McConnell wouldn't take it up. So for two reasons, hemp was added in. One, because the hemp business, Elevon had just exited the market at this point. Nobody was able to get processing, so we really wanted to make sure that banking was available for hemp. But two, McConnell, being from Kentucky, he has a lot of Kentucky hemp farmers behind him who also are having trouble getting banking. So by adding that hemp provision in, it'll put more pressure on McConnell to bring it to the floor, especially in a primary year.
So we're about 5 minutes over, so we're going to stop for now, but I'm going to hang around here. Well, but thank you very much for listening.